Hello, good afternoon, everybody. Welcome to our live. We are going to talk about the AI Act and intellectual property, and we see that we are really quite on time. So let's wait a couple of minutes for us to get going. And I'm here with Luca Egitto, Mr. Luca Egitto. And
Hello.
we are going to start in a couple of minutes. Let's wait for people to join. Hello, I'm just going to welcome again, everyone once again. We are just starting our LinkedIn Live to talk about intellectual property and the AI Act. And together with me is an expert, a professional, and also a good friend, Luca Egitto. Luca, welcome. We are going to start our conversation in just give us a minute so that, we also will wait for some viewers to join in, and just repeating this message once again for those who are just joining at the moment. So 30 more seconds, one more minute. Let's do one more minute and then we'll start. Okay, fantastic. Let's begin. Good evening, everybody. Welcome to our fireside chat about artificial intelligence and IP, intellectual property. I'm Shalini Kurapati. I'm one of the founders of Clearbox AI. And together with me is Luca Egitto, who is a practicing lawyer, an expert in intellectual and industrial property law, as well as IT and data protection. And he's also part of many international associations, including IAPP and also the International Trademark Association. So he's quite well versed also with not only the IP law, but also the technological aspects of it. So I'm very excited to have this conversation with you, Luca. And we are going to discuss a lot of things, a lot of questions, a lot of, I think, we also see a lot of interest in this topic. And also, for thanks everyone who is joining us on this live. And please leave your comments or questions. We'll try to answer as many as possible. This also needs to be a discussion. We are here to also, hear your view as well. So just to set this straight, I mean, we have different profiles of people who are joining us. So just to set the kind of stage, I'm just going to give a very, very brief and really a high-level introduction to AI Act. I know we could spend the whole afternoon talking about AI Act or days talking about AI Act, but just a very brief introduction to AI Act, and also the relationship with IP and what are the challenges around intellectual property and AI Act, and in general, copyright law itself. And we're going to have some discussions about it. Yeah, what do you say, Luca? Shall we do that?
Yes, please go ahead.
Yes, let's do that. Okay. I'm going to just quickly give you a very, very brief introduction. Okay, so you must be seeing my screen now. So firstly, welcome everybody once again. Really excited to be here and to be talking to you about this topic. And just like I said, what is the AI Act, the EU AI Act especially? It's like it is the first ever comprehensive legal framework in the world to actually, as an attempt to regulate AI, to govern AI. We don't have anything like that anywhere else that's comparable. So, and you must have been hearing about a lot of news about AI Act over the last few months. The council, the trilogue, the parliament approved, the ambassadors approved it. So there's a lot of also many dates and many significant milestones to kind of wrap that up into when did it start and when it's going to be in force. Very briefly, what started off as a proposal in 2021 went through a series of legal procedures, legislative procedures. And last week or recently, we've had the European Parliament also adopting the AI Act. And so the legislative procedure with all these European bodies and institutions has come to almost a final stage. And we are ready to receive the official text, which is hopefully going to be published in May or June this year. And once it's published, in about 20 days, it will actually enter into force. And there's a kind of a grace period of 2 years where companies can prepare everything to be in conformity to this legislation. So this is kind of in 2026, then it's really there. Anywho, and here, what does AI Act do is it kind of divides AI systems into based on their risk. So you have the really minimal risk systems like spam filters, which don't really need to comply with all the obligations of the AI Act. And then you have the, let's say, medium risk systems like AI systems that can generate deep fakes, AI generated content, etc. And they are kind of like medium to low, medium level, which have much more transparency obligations. That means that you need to tell them that this is AI generated. You need to be much more open about your about the fact that it is AI generated. And then you have the high risk systems such as robo-operated surgeries, or banks using it for mortgage applications or for social security benefits, or even surveillance, etc. It's high risk, so they have a stricter conformity assessment. They need to have a lot more transparency obligations, and there's post-market monitoring even once it's out there. So that's high risk systems. And then you have systems that are unacceptable risk, which are completely banned, like social scoring, for example, that you cannot score people based on AI. And this was like kind of the original proposal. And more recently, they added what you see on the bottom is the general purpose AI models, which are also foundation models. That's where the generative AI comes in, where you have all the they kind of completely shook up the AI Act. So the general purpose AI models, which could actually create systemic risks, have been added as well. And that's where we are going to talk about it, because the generative AI part, which are most of it are based on the foundation models, are the ones that are also creating a lot more confusion about what is related to IP as well. So, and some of the requirements, the aspect is that with respect to intellectual property, even though on fundamental rights have been well addressed, on terms of intellectual property, the AI Act kind of only scratches the surface. One of the requirements are, for example, companies need to kind of disclose what copyrighted data they've used in training. And there's not much information about what happens to the generated content. And of course, these kind of requirements are more of the transparency requirements with respect to data, computational power, models. So it's kind of more categorized under that. And more recently, you must have seen also some of the lawsuits that have been filed with AI-generated content. For example, Get Images, you can see in this image that there's even a watermark that has been generated by one of the generative AI tools. And also, New York Times is suing OpenAI on the use of copyrighted work, citing kind of a fair use. And there's a lot of confusion about this. And at the same time, you also have companies like Shutterstock, Google, and Reddit kind of making data licensing agreements. That means they're actually selling data for AI training. So there are different business models emerging. And Google, of course, recently has agreed to a 16 million per year deal with Reddit to actually get their Reddit data. And immediately the Federal Trade Commission actually started an investigation about this, because there's a lot of unknowns. And at the same time, AI Act actually, based on the current form, it actually poses more questions than answers with respect to intellectual property, because there's a lot of nuances there. So today we are here to answer some of those questions. And I couldn't be happier to have a better sparring partner than Luca Egitto because he's really perfectly, uh, you know, uh, on the theme, both from the legal side as well as on the technology side. So really excited about that. So Luca, let me start with asking you. I just gave you a quick introduction.
Yeah.
Give us a little bit of overview, a kind of bird's eye view, if you may,
Yeah.
of IP, AI, and the AI Act altogether.
Yeah. Yeah. So thanks for giving me this opportunity to discuss this, Shalini. So it's very exciting, but at the same time very challenging, as regulations such as this uh, are based on principles rather than specific commands towards users and businesses. So it gives recipients of the regulations some room to interpret and also to pursue their own policies. To some extent, this resembles to GDPR. And at the outset of GDPR, we were all very, very hungry for specific examples, guidance on interpretations, policy examples. To some extent, we managed to do that on our own. To the other extent, we received some support from institutions. So the first thing we should look at is the AI office, which was created, from which we expect some kind of support in drafting documents and giving guidance and interpretation. It is true that the current text, which is being circulated, is very high level and only addresses the aspects of training data. So it doesn't deal directly with the output. Also because, and this is my personal interpretation, AI is not just generative AI. So we are now kind of obsessed with ChatGPT because it made the news in the last 18 months and basically anybody is talking about it. But AI is not just generative AI. And then I have my personal view on why this was not addressed, but I will leave it at a second moment. The first thing to address is training data, which is one of the most debated issues, also because of New York Times, the New York Times lawsuit. So, in a nutshell, it is widely known that general purpose AI requires huge amount of data, requires huge computational power, and gain momentum only when these excellent machines, which were developed years ago, had enough data to be fed with. Now, it is widely known that basically all internet pages were scanned and read to do that, but that gave rise to a number of concerns about copyright owners. And these concerns were reflected into the preambles, the recitals, and some provisions. These provisions mainly address how you train data and the information you use to train data, as there is a concern that some of this information can be proprietary information. So we're now focusing on an issue regarding property. So the vast majority of the concerns that you have brilliantly outlined regard fundamental rights. This is slightly more specific regards property. So is anybody being harmed by the fact that I am training my model with so many data? And the answer is yes, there is somebody concerned, and these are media, publishers, authors. Uh, we can also look at the audition of Condé Nast CEO at the U.S. Senate, where he plainly alleged that OpenAI and companies similar to OpenAI are banking upon the huge amount of data which is available online to create something which is going to be a competitor to traditional media outlets. Now, it's debatable whether it is
Now,
exactly like this,
that's
but the
that's
concern is real.
No, that's a very good point, Luca. But two things here in terms of training, because they have been training over the data over the internet. How do you see this different from, let's say, text and data mining, which is accepted in Europe, for example? And
Yeah.
what kind of protections that we need to be thinking about? Because it's also not just a legal issue, but it's also a technical issue. Like, if we have to protect the data, how are we going to ensure that you have the audit trails of all the data that you have trained, and how can you prove and summarize these things? So in the existing, so for example, even when we're talking about New York Times, and some of them cite fair use, like what is so different that a person is reading a newspaper article and now summarizing the ideas and
Yes.
using it in their own words? And so what protections are available today, and how do you see this in the future?
Yeah. So in Europe, let's say in continental Europe, we don't have a specific fair use exemption. We have exemptions which are not identical to fair use. There is an exemption in the 2019 copyright directive regarding text and data mining. And this exemption applies not just to educational institutions and public research institutions. There is a language suggesting that if data mining is necessary to promote innovation, it should be exempted from copyright restrictions and enforcement. So this is also mentioned in the AI Act. So it is possible to resort to this kind of exemptions. The point here is that models are often trained to create commercial products in the strict sense. So it's debatable whether resorting to these exemptions will be available to anybody who is training data with publicly available info. Secondly, the protection that copyright owners have is theoretical. We all know that in Europe, you don't have to register for copyright. You are protected for the mere fact of having created a work. Now, you don't have a certification, a legal watermark. You, as author, need to watermark your stuff. Now, there is an obligation in the AI Act for providers, for those who train data, to make sure that they don't infringe third-party rights and that they also disclose the data that they're using. This is a suggestion on how things could go. So if there is an obligation to disclose, then this is where you allow right owners to intervene. Because clearly, if it was the burden entirely on authors, it would be practically impossible to investigate into the black boxes. So the providers are now bound to disclose how they train their models. And by disclosing this, they might allow right owners to inquiry and take action. So this is already a symptom of the fact that the AI Act does not give clarity and certainty. It puts the burden on one party, but then also on the right owner to take action. This is one thing, and concerns predominantly literary scientific work, which is in written form. But it could also concern graphical and figurative art. Now, at the moment, it's unclear to me how you clearly identify this as a component of your training set and how you disclose this in a sufficient clear manner to allow right owners to intervene. But there's a third thing which is definitely relevant because it's mentioned in the 2019 directive, which is database rights. So database right, and in particular sui generis right, protects specifically bunch of data which are extracted and reused. And this is the core of data training, as far as I know at the moment. Now, this would be easier to spot, but relies on the transparency and loyalty of the provider. So this will be the game changer. So the ability of providers of identify protected content to disclose this and to allow discussions with right owners. But at the same time, there must be some guidance on how to apply the exemptions in the 2019 directive for data mining, because it's going to be the real game changer. And also to allow competitiveness of providers based in the EU, because at the moment there is no regulation in the US uh, comparable to the AI Act. So there might be some discrepancies, giving some advantages to US or non-EU providers.
Yeah, but what do you say about the copyright laws, especially in the EU, is interesting because that means that you don't have to really, ask for it. You're kind of given to it just because you've created something that what you've said,
Yeah,
and from a technical perspective. So I've been looking at what could be opportunities for people to assert their right about a particular product that they have created.
yeah,
And there are some initiatives that I've seen. For example, there is something called the Numbers Protocol, which is based on it's kind of a decentralized network where you can assign ownership, and you're kind of saying that I was here first. It was mine first, and you kind of have
yeah. A
on the
timestamp.
blockchain. It's yeah, exactly, a timestamp that is kind of verified. At the same time, I also know that a group of public-private organizations, including Adobe, for instance, have started something called the Content Authentication Initiative. So basically, it's
Right.
kind of it's a hash that you attribute to a particular product, a digital asset, where you can see the trace of the metadata. So that it's kind of a tamper-proof metadata. So as if you convert it or you reuse it, it gets added. So you kind of have a provenance. And the two things here would be, in terms of training data, is kind of one thing is maybe attribution. So people would like to be at least credited for their work. And the second thing could also be compensation, especially if you're talking about artists or photographers. So how does that? I mean, is it being even looked into, or are there any ideas that are coming around these topics?
I think there are ideas, but not at institutional level. So I don't think that the EU regulators and institutions are so creative and proactive also to suggest the means. But we also have to take into account that legislation is very slow, and any recommendation which is too specific and too technology specific is at risk of being outdated very easily. So they are kind of reluctant, and I understand that, in setting forth specific paradigm or protocols. But for example, if you look at the Data Act, which imposes an obligation of disclosure of certain parameters of IoT, for example, they suggest that smart contract could be one technological means to exchange information and to track information in a very in a solid manner, in a reliable manner. So this could be one option. So to watermark and to tag your stuff so that you can be recognized among the various materials that are used to train. My concern is that this whole thing could be so cumbersome that it might be disregarded and just ignored, and it would be an utter failure of the AI Act. On the other hand, what could happen is some sort of economic compromise between the different stakeholders in order to provide a sufficient remuneration or recognition, because remuneration is the core issue. So I don't think that there's a great deal of moral rights against a machine. And I don't think that authors are so concerned that uh, about being recognized as one of the authors used in a data set, because it could be millions. So it doesn't make much sense for them to stand out, because they wouldn't stand out. They would be just one needle in in many other among many. Whereas on the other end, remuneration could be something they should look at, but this would apply in particular to very technical data sets. So I'm thinking about scientific data sets, or those realms where AI is used to research in a much more effective manner. For example, scientific research for medicines, uh, cancer research. Uh, this is where you should feed the machine with very competent content, with very specific content, which normally is paid for. So that is something that is relatively easier to achieve because it's a very professional. My concern is about very large multi-purpose models that need any sort of information in terabytes. This needs quite a political and economic compromise between the stakeholders, because we cannot, afford to lose this race as Europeans or in Europe. But at the same time, I think that the world may not do without a Europe in developing AI. So there should be some sort of compromise at global level between stakeholders. So and yeah, so
Yeah, that's definitely. I mean, you make a very good point. But in terms of moral rights, actually, I would also like to add something more than that. That not there could be groups of communities that could be very much interested in moral rights as well, especially as you mentioned, researchers. I've worked also a lot on the open data Creative Commons side,
yeah,
where you share your findings as much as possible, and their biggest reward is actually if somebody else reuses it, if they attribute that they have used their data set. So actually data sets, the way that is, they're also being published like on platforms like Zenodo or other open data platforms, they actually have citations, so you can actually cite a data set. So basically they get cited and they
yeah,
get recognized there. And
yeah.
at the
That
same
must.
time, we are also seeing some creative ways of some artists who are like kind of rebelling against this kind of don't use my data. So I've seen also the University of Chicago, for instance, has a group that works exclusively on creating tools and platforms like Nightglaze, I think, and Nightshade and Glaze. These are tools that will let to change their especially images, to change the images by a few pixels here and there, which is not discernible to the human eye, but to the AI model it's a kind of data poisoning. So they kind of learn completely different things and they reduce the style mimicry. So I think the moral rights are also kind of playing an important role in the whole IP debate
Yeah,
in this
yeah,
field.
they do. They do. My comment was just based on the incentive of taking action to assert your moral rights. So in some cases, you don't have such incentive because you normally go after the money and you look at that. But for example, you're perfectly right. If you are within a technically competent or scientific or academic context, uh, asserting that you are the author of a paper is essential for your future and your career. So this is where you have an incentive. But I don't think that that would be a problem, because my feeling is that uh, vertical solutions that regard specific scientific
Mhm.
matters and practices are more akin in seeking authorizations and finding a decent solutions. But
Mhm.
it's easier for them. The big issue is the multi-purpose,
Yeah.
multimodal. They need vast amount of information, and simply going after every single individual is not viable. They need bunch of data
Is
and
absolutely.
use them. So um, I'm, I'm just trying to predict what can happen, but it's just my guess at the moment, and reasonable
No, no.
guess.
I mean, it Absolutely. I mean, I think a lot of people are grappling with these problems, and we've talked a lot about training data. And another important bit we have to address, and I also encourage our participants, if you have questions, please do post it to us. Is we've talked a lot about training data, and in lieu of time, I would also like to spend some time on the generated outputs
Yeah,
of AI. So, and with respect to IP, I think that's also something. There's a lot of questions also about it. And how do you see that, Luke? I mean, I really, you know, I'm happy to
yeah.
hear that from you.
Um, it could be to some extent easier to address this issue because the output is is not just tangible, but is out there for you to assess, right? So whereas all the data in the background are too many, too complicated, too intricate to double check, the output is can be assessed as a whole, and it would fall under general liability rules. So the deployer of the AI system, or if you prefer, the user of the AI system, has a liability in the output. So it cannot rely on the fact that the machine is sufficiently critically thinking and autonomous to shift liability. Liability is not going to be shifted onto something which is neither a legal entity or a natural person. So somebody would be liable for the output, and um, in that case, you have a judicial scrutiny on the training data. So in that case, I suspect that a court will ask for a full disclosure, will appoint an expert to review this disclosed material to understand whether in the background the training data is a debtor of a previous protective work, so that the output is either a copy or a derivative work. So in that case, you just need to look at the output, and if somebody is unhappy about the output, it will take action, and then it will be a burden of the deployer to prove that it all happened by chance. But the consequence would be the traditional consequence. If you, even if you did not copy on purpose, if you end up with an identical work to a previous work, you are barred from using it. So this is relatively easier to address, not easy as such, but easier to address compared to the whole amount of training data and tracking who did what, I think.
Yeah, but we also, when we had our preparation and discussion about this, and you also cited a court case. This is not about really infringement about the whether it was a copy or not, but if it's a generated content, let's say a new data set or a new image or a new movie nowadays,
Yeah.
who is the owner of this? And who gets to claim? I mean, who gets to claim a copyright over this, and how can they protect that? And I mean, these are the new questions that will also come up, right? And you also gave the
So
precedent of a court case.
So, considering that we are not yet in the Terminator era, so we don't have autonomous machines, machines that can, rebel or riot against human beings. All these systems are controlled by entities. So these entities can claim property on the output, but I think that the human intervention, at least in combining in a creative manner the outputs, or combining and controlling the pipeline, uh, would be required. Uh, but again, we have some landmark cases being discussed. We have a precedent, if I'm not mistaken, in Italy, which states that there can be copyright claim by a legal or a natural person, even if there's an AI developing the code, provided that there's a person in the process putting human expertise and, let's say, sweat of the eyebrow in deciding how to combine these factors and to give uh, their own imprinting to this output. So again, we will need some case law to determining this, but at the moment, copyright focuses on human beings. So the author, still the originator of the copyright, is a human being at the moment. So you still need a human being putting some creativity in the process.
Yeah, I mean, this is. I mean, I've been like trying to gather all our points that we've been talking, and from the beginning we talked about copyright law and how in Europe we talked about fair use, which is a bit more in the U.S. than Europe, and sui generis database rights, which are actually very European. And however, AI is not just European. It's a
Yeah.
global phenomenon, and most of the AI models that we are using are not European. And how are we going to battle with the different copyright perspectives from the US and EU? Are there any initiatives to kind of unify these efforts?
Um, well, I have to say that despite the inherent differences between the two worlds, so the US and Europe, when you look at copyright, there is some sort of harmonization which goes back even in the centuries. So, although the US, especially, didn't recognize moral rights, and on the other hand, continental Europe had its own authors' right tradition. We had a lot of conventions through the centuries that tightened the two systems, which are now quite harmonized worldwide. So it is true, for example, that the US don't have a sui generis right. At the same time, they have case law rewarding the creator of a database in a manner which is not so far from what we do. At the same time, we need to accept the fact that the sui generis right was relegated to um, almost non-relevance here. So the differences are not so thick or relevant, and I think that worldwide the copyright system is somehow harmonized. So this is not the issue. The issue is that Europe is at risk of over-regulating an ecosystem which is already driven by other continents. So we should ask ourselves whether what we're doing is enough to protect people, but at the same time is appropriate to foster innovation, because we are at risk of over-regulating and stifling and suffocating innovation. So copyright is one of the risks. The other one is data protection. So there might be some ways to accomplish the two things. So protect people and promote business. In regarding data protection, we are already used in anonymizing data sets so that they can be used forever without falling under the GDPR. We should now find something to clear data sets so that copyright owners are happy, and developers and providers can make further research and enhance their products, because this is what we should aim at.
Yeah, I mean, actually, given these trends, what I've also been noticing is like until the whole data reuse, data sharing, which is essential for innovation and also for AI projects, which was kind of like you rightfully said, was kind of blocked by also GDPR in many ways. Now it also seems that many organizations might cut off the access also because they don't want to be either inadvertently providing it for training an AI model without being compensated or attributed. And now that there are new data licensing, data monetization opportunities, they might be pursuing there. So I also see that there's much more, even though there is a lot of transparency requirements, there might be a lot more closing off of access to data
Yeah.
set, and the data is going to
Yeah.
become kind of much more of a property that's going to, like, a, I don't know, a heritage of the company, let's say, uh,
Yeah, yeah. So
for the years to
this is
come,
the risk.
as we can see how.
Yeah, yeah. So
Yeah,
the closure, the risk
absolutely.
of is there. So you can see in the AI Act that the provisions clearly state that IP and trade secrets should be protected. And so there is another example in the Data Act where they say the obligation to disclose how certain technologies work should not jeopardy uh, IP rights and trade secrets. So there is a risk that businesses would close themselves because this is how they are sure to protect their investments. Uh, but that would be the failure of the AI Act. So I expect the AI office and I think also ECJ, which is going to be definitely involved, would provide interpretation and guidances that would allow certainty among entrepreneurs and technology developers, because otherwise, again, I'm sorry to repeat myself, it is going to be an utter failure, and we don't need another failure.
No, yes, I definitely share your fears that we don't want to have a law for the sake of the law. Like, okay, we are governing AI, so we need to have a law, but that should not jeopardize it. Jeopardize it. At the same time, what I've also noticed in the AI Act is that some parts of the AI Act are very high level and open to interpretation on aspects like
Yeah,
IP law, because they are like, okay, I think you're going to figure it out with the copyright law that is there, and like you also said, we are more concerned about fundamental rights and rather than IP rights. At the same time, I've also noticed that they have given very clear technical details about the size of generative models, for example. So what I also sometimes see is the disconnect between, like, for instance, they even describe what level of computational power each foundational model should have to be considered as a systemic risk, which is, I think, a very operational and a technical detail. And for some other things, it's very high level. So, and since AI Act will require not just lawyers to implement it, you need technologists and people who understand the systems all working together. We also need to come up with strategies and solutions that both parties can work together. It's not just either technical people or policy or legal people. And this is where I see the gap, and I think we need to really work on this to actually make it a success and not just another bureaucratic
yeah,
nightmare.
yeah. So the, we always have a risk when we try to regulate technology. So technology runs too fast for legislators, not to mention that the EU legislator is inherently slow because it has together too many decision makers in the process. So there is always a risk of delivering something which is already unfit. Um, Standards, protocols are exactly what should be pursued. You can't pursue a policy at legislative level when it's so technical. You should ask associations to work to deliver technical guidance for example, for interoperability. So a clear manner to allow independent review and audits of data sets, uh, an efficient manner to extract aggregated information on the data sets to understand whether this is where right holders should look or not. And also competitive standards for right holders to, to release their consent in exchange of a decent and satisfactory compensation, taking into account that digital information is not unique, so you cannot request exaggerated amount of compensation for something which is used in a flash and is just one needle among billions and billions, if not trillions, of items. So there must be some sort of compromise, not necessarily regulated centrally, but rather by industries and right holders. So that's my educated guess on what could happen in the future.
No, thank you so much. And we are almost coming to the end of our live, but I really, if you're, our audience members who are joining us, please feel free to, if you have any questions, put them in the comments. If we don't manage to answer them right now, we will try to also answer them also in the comments on LinkedIn or YouTube, for sure. And I was just reading and remembering a quote, Luca, of Banksy, the artist. He wrote in one of his books like copyright is for losers, but it's and I would like to it would be interesting also to hear your opinion. I mean, he does license his work as well, so despite saying that. So I mean, I'm also trying to see also how this is exciting time, also both from a legal perspective or a technical perspective, how things will pan out. And who knows, there might be a time where there will be everything is copy left, and the protections don't exist on the copyright side, and there will be a new paradigm of how we use data and reuse data, and it's all there to find out. And in the meantime, both as technologists, as legal professionals, we'll try to see what's possible and try to innovate in a way to find creative solutions to address these issues, and also work so that we are protecting fundamental rights and not stifling innovation. And I
Yeah,
hope AI Act also tries to achieve that in the future.
yeah, sure. Yeah. So one final thing is that in the end, so I'm not a fan of how Banksy addresses the issue of copyright. At the same time, I think that all the people involved um, in the process are not necessarily uh, greedy. Most of the people just want their work to be rewarded. So I think that it is okay to find a compromise which creates some balance in economic terms, and does not, misappropriate unduly the outcome of somebody else's work. At the same time, if there are so promising technologies, we should not, hinder them on the basis of principle that sometimes date back to 2 or 3 centuries ago. So we're now in 2024 and should look at it in a different manner. So again, it's a very high level remark. I appreciate that, but that's the best we can do at the moment, because it's still in the process. It's still to be AI Act is still to be published, but it's good that we talk a lot about that. But we should focus also on creating technical skills to further develop this technology. So we as lawyers are not so necessary, and we did a lot of work in this legislative process, also in explaining how it should be interpreted. But now we need people to develop and to create more and more technologies for this to thrive.
Perfect. Thank you so much. I mean, firstly, thanks a lot, Luca, for joining us today in this
Well, thanks to you.
live, and thanks everybody who has joined us also to be part of this discussion. And we promise you, in case we are not able to answer your questions right now, we will do so also offline. And really, this is, like Luca said, there's still a lot of uncertainty about AI Act. The text hasn't been published yet, but we really need to start talking about this, because we have to find solutions to make it work in a responsible manner.
So it's not published. Shalini is not published, but the version which is
there. Yeah, of course,
is there, and we know that there are certain obligations regarding copyright which will be certainly in the text to be published. Yeah. So this is just the handful of provisions, but they have a big impact on copyright. So it's already there, and it's good to discuss it.
Yeah, and how to interpret it, right? That's the devil lies in the detail right now.
Yeah.
Yeah. Sounds good. Yeah, absolutely. So, really exciting times to come for AI, for IP. Stay tuned. We'll be having more of these conversations, hopefully, also in the future. So, thanks everybody for joining us and have a lovely
Bye.
evening. Catch you again.
Bye.
Bye
Bye
bye.
bye.